In a request filed before the Supreme Court, National Peasants Party leader Robert Kasibante seeks leave to withdraw the presidential election petition, which he filed against President Museveni, the Electoral Commission and the Attorney General. All parties had complied with the filing directions, and the Supreme Court, sitting as a 9-justice panel led by Chief Justice Flavian Zeja, had fixed today, 6th February 2026, for delivery of its ruling. Attorney General Kiriwa Kiwanuka says his team had invested a lot in the case and that court is there to notify them on the way forward.
The petitioners have filed an application to withdraw the petition. The respondents are required to file their responses and then get guidance from the court on how to proceed. So the court will give us a date for hearing the application after the processes have been undertaken, after we file our responses, and then the court can fix the hearing. So we've put in a lot of time and work. We were ready for the hearing. Obviously, we'll be affected, but at the end of the day, what we're asking the court to do is to dismiss the petition. So if the petitioner withdraws the petition, we can't oppose it.
Kasibante had sought a comprehensive audit of election material, including declaration forms, biometric voter verification records, scanners, and electoral servers used across the country. According to the latest application, Kasibante now argues that carrying out the proposed audit would require processing an enormous volume of electronic data nationwide to a tune of about $7 million, an amount he says he cannot raise.
To petition a case in a Supreme Court, you need like $3 billion. I sold all what I had to have this case filed here. Now, adding more $4 billion, that means I'm going to be announced a bankrupt. And now, how will I be moving in Uganda when I'm a bankrupt?
Kasibante, who proudly reveres NOP leader Robert Kyagulanyi, has lashed out at other opposition political parties for turning a deaf ear when he launched this litigation battle.
This we communicated to most of the political parties, the opposition political parties. We requested them to have support, to support us in that area. But most of them were adamant and they did not even get response to us. They did not respond to us.
He had accused the Electoral Commission of having conducted the election in total non-compliance with the law, seeking court orders to nullify the election of President Museveni and for court to order fresh polls. Former Deputy Attorney General Mwesigwa Rukutana represented the Electoral Commission.
We are both happy and sad. We are happy because finally I think the petitioners have realized that our clients conducted the election in compliance with the laws and principles laid down in the law and the Constitution. That's why we were happy, because they had challenged our clients' conduct of the election. Now that they have decided to withdraw, it means they are satisfied that the elections were conducted in compliance with the law, contrary to what they are alleging. We are not happy because we put in a lot of time doing research. Then as lawyers, we had expected a precedent because we had guided the court in our submissions on how to treat this application. And if this Supreme Court pronounces itself on the matter, then as lawyers and the country would get precedents on how such an application should be handled. But this one will not come because now, though the ruling was ready, it couldn't be read because the petitioner, the applicant, has drawn both the petition and the application.
Under Section 59 of the Presidential Elections Act, the Supreme Court is required to conclude the hearing of the petition and deliver its judgment within 45 calendar days from the date of filing, which was January 18th, 2026. Juliet Nalwaga, NTV.